Hi, and thanks for joining us for today's PII webinar on community legal centres and Section 229BC of the Criminal Code mandatory reporting. My name's Penny Sullivan. I'm one of the team here at Community Legal Centres Queensland. We begin, as always, with an acknowledgement of the traditional owners of the land on which we're holding today's webinar. In Meanjin, Brisbane, they are the Turrbal and the Yagara people. We pay deepest respect to elders past, present and emerging. As this webinar is being viewed by people across Queensland and around Australia, we also pay respect to the traditional owners throughout the country. We recognise Aboriginal and Torres Strait Islander peoples as the traditional custodians of the lands of Australia and recognise their continuing connection to land, water and culture. We acknowledge the stories, traditions and living cultures of Aboriginal and Torres Strait Islander peoples and commit to fostering a culture of learning from and working with First Nations peoples in the spirit of reconciliation and access to justice. We extend a warm welcome to any First Nations people listening today. So we're very pleased to welcome Bill Mitchell, the Principal Solicitor at Townsville Community Law, to talk to us about the application of Section 229BC of the Criminal Code, which creates an offence for any adult who fails to disclose information that causes the adult to believe on reasonable grounds or reasonably to cause the adult to believe that a child sexual offence is being committed or has been committed against a child by another adult. Bill will discuss operational aspects of the duty, the application of the duty to community legal centres, as well as canvassing key controversies and some practical steps. So we're going to hand over to Bill in just a moment, but before I do that, just some quick housekeeping. Today's webinar is being recorded and we'll have that recording available to download later today or early tomorrow. A link for the PowerPoints has been emailed out to everyone who registered. You can also download it from our website. It's also available from the handout section of your GoToWebinar control panel. We do encourage you to ask questions. Please simply type your question into the question box on the control panel and we'll read your question out. We will hold questions until the end of the presentation, but feel free to type them in as you think of them. As I said, if you experience any technical issues during the session, can you please email me at penny@communitylegalqld.org.au. Terrific, that's it from me for now. I'll talk to you again at the end of the session and I'm going now to hand over to Bill for his presentation. Thanks so much, Bill.
Thanks very much, Penny. Can I just make sure people can hear me as well? So if you can stick up a hand, great. Look, thanks very much for inviting me to present this session, Penny and CLC's Queensland. It was to be presented, as people know, at the CLC State Conference as part of the professional indemnity insurance process and I guess a module to focus in on some of the work we do. Unfortunately, that was delayed, so we're doing that now. So hopefully there's a whole bunch of principal lawyers out there listening in, but look, to be honest, I hope there's also a bunch of people within CLCs who are having first contact with clients or prospective clients, because this is just as important for them. Can I also acknowledge the traditional owners of the country that I'm coming to you from? It's the Wulgurukaba and Bindal peoples here in North Queensland, and I pay my respects to their elders past and present, and those who are emerging, particularly within legal centres and legal assistance providers. And can I also pay my respects to any First Nations people in the audience today. The scope of the session Penny's already covered, and I'm not going to repeat that, but I'm going to give a caution and say this is a highly technical and developing area, and it is an area that warrants continued observation, and I guess we don't have too many examples so far. We have some practical experience of the application of this section, but not a huge amount. So at the end of the session, it will be great to hear from you whether you've had to deal with these issues more than anything. Look, despite this being a technical and developing area, I'm going to move through a lot of heavy content quickly. You will get the slides. They contain references to laws and cases where necessary, but I'm going to take it for granted that we can move through a fair bit of content today. So why are we talking about this? Well, this follows the Royal Commission into Institutional Responses into Child Sexual Abuse it's a new scheme. Well, not so new now anyway, but it's a newish scheme. It's a part of a broader policy to protect mostly children from sexual assault and sexual abuse. And considering this duty may well be a regular occurrence for CLCs or other providers and their staff. But more importantly, we're talking about it because there's some complexity around how it applies to us and our clients. And it has the potential to impact quite significantly on our interactions with our clients. There are consequences, including imprisonment penalties, and there's a whole bunch of other potential consequences tied up into our ability to deal with this provision. So let's jump straight into the overview. You've all heard this already, and you may well have looked at it. But 229BC of the Criminal Code says that if an adult gains information that causes them to believe on reasonable grounds that a child's sexual offence is being or has been committed against a child by another adult, and there are some requirements about the age of the child, then without reasonable excuse, they can't fail to disclose the information to a police officer as soon as possible. And we're going to break this right down. We're going to look at each of these elements in turn. But that's the overview. As always, I go to the explanatory notes when I'm a bit unsure about how things work. You know, obviously we've got to have ambiguity, and I think this is a case where there is a good deal of ambiguity. Unfortunately, in this case, the explanatory notes don't really tell us much more than what the bill and the Act say themselves. They say that a number of circumstances have to be met. Firstly, the adult gains information that gives them a reasonable belief about an offence. At the time that the offence they believe is committed, it's a child either under 16 or is 16 or 17 with an impairment of the mind, and that there's an absence of a reasonable excuse and the adult fails to disclose. Again, this doesn't tell us much at all. So let's break it down even further. Before we go there, though, it's important to understand that this is imposing a positive duty, and this is not just a duty on us in CLCs. This is a broad imposition of a positive duty, and so that's the central purpose of 229BC, is to create a positive duty to report child sex offending, essentially. There are some clear provisions around how it applies. And this has caused a little bit of confusion for some people, but there are two essential criteria about its application. The first one is it applies to any information gained after the 5th of July 2021. So it applies to information that we get after the 5th of July. But it applies to alleged offences before and after the commencement of the Act. And so this legislation or this provision has both retrospective and prospective application. This is really important because the information we get could date back quite some time, and the application is retrospective in that sense. It does require whoever gets the information to form a reasonable belief. And, you know, what is a reasonable belief is, again, one of the points of ambiguity. I'm not going to get bogged down in this because there are many, many points of ambiguity in this provision. However, the Queensland Government itself says a reasonable belief could be formed by someone, for example, a child telling you, or someone telling you that a child has been sexually abused, or where there are signs of sexual abuse. Now, our clients, or the people that contact us and give us the information, are more likely to fall into that first category, but they may well fall into the second category as well. This is not an exhaustive list. And there's a good article by Philip Swain about what is belief on reasonable grounds, which was really looking at the Victorian equivalent of this, which came into being quite some time back in Victoria. So if you're wondering about what a reasonable belief might be, there's a good article there by Swain. But really, I think most of us will have a sense of that by the time we get through all the material. So firstly, we need to ask ourselves, who does this duty actually involve? Well, firstly, the information is critical. It is the person who gives the information, which could be a victim, it could be a perpetrator or a third party. And then the adult that gains the information, which for the most part is us. the duty involves an allegation, and that is a child who was either the victim of a historical or current child sex offence, or in fact we'll see the offences are broader than that, and another adult. The allegation necessarily involves a perpetrator of a child sex offence. And in terms of reporting, it involves the police. So you can already see that this duty involves many different parties. The person giving the information, the person getting the information, the person for whom the information involves, and third parties like the police. I'm going to be talking mostly about our role, which is the adult that gains the information. This question of impairment of mind in terms of reporting for children who are 16 or 17 is another point of ambiguity in my view. It's defined in the provision as you can see on the screen, but I really have a question which is a threshold question, that how would we know that this was the case in any given situation? And what also might occur is if we hear information, as an adult we gain information about a child, and we gain that information through a substitute or supporting decision maker. And so there are many loose ends and open questions I still have about this, but this is an additional requirement for those who are 16 or 17. It's trying to catch, of course, young people who may be less able to disclose or less able to protect their own interests in that age group above 16. The information that we get about a child sex offence has to be at a particular period, in a particular period of time. We need to form a belief that an offence was committed, or ought to form a belief that an offence was committed at a particular point in time. So this additional requirement does actually also seem to require a bit more detail from us. So it's not enough to know that a historic child sex offence has occurred, or there's an allegation of that. Really, we need a little bit more detail about these things. And so in order to form the reasonable belief, we also have to have a belief about when the offence was committed. This is very difficult, obviously, because many of the allegations we get about historic offending is also subject to people's very serious health issues that coincide with their experience of abuse, people who have memory issues, cognitive impairments of some kind, psychiatric injuries caused by this abuse. So again, we're being asked to really understand detail that is not going to be obviously forthcoming every time. So it's really important that we, after this session, you look back through these slides and look at each of these key elements, because when you get a case where you think you may have to consider the section 229BC, these are the things you'll need to think about. So this relevant point in time is an important one as well. What I think is less known about this provision is what is a child sexual offence. And again, this is very complex because it is not exhaustive. It includes, at the very least, all those Chapter 32 offences, which include rapes and sexual assaults. But it also includes Chapter 22 offences, of which there are 29, which are offences against morality. But it also is drafted in a way that it is not exhaustive. So in fact, it could include other things. What this is doing is making sure that the duty follows from the broadest possible allegations of child sexual offences. So don't think that this only applies to those most serious offences in Chapter 32. It applies far more broadly, and it's worth you going back and looking at Chapter 32 and Chapter 22 at some stage as a way of understanding just the breadth of what is included as a child sexual offence. The critical part of this section is its retrospectivity, and it only has a partial retrospective application, but this is very clearly articulated by Parliament as a way of protecting victims of child sex offending. They are vulnerable, and it is incumbent on those in the community to make disclosures for them, because they often don't disclose, or they may not be comfortable disclosing on more than one occasion. And we know that people who have to continue to repeat these stories, that carries with it a traumatic impact. So this retrospectivity is very much imposed on us to protect children, both from the things that have occurred to them in the past and the things that may occur to them in the future. So what must be done? And that is really the essence of what we're talking about today. So if without reasonable excuse you fail to disclose information as soon as reasonably practicable, then you've committed a misdemeanor. There's a penalty of 3 years imprisonment. So if you gain information about a child's sexual offence, which has happened or is happening, you have a positive duty to disclose as soon as practicable. But this does mean you have time to consider the factors, and that's the points I've just raised. But really, what we're talking about here today is relevant, reasonable excuses. Now, I'm not suggesting that we would be overly reliant on reasonable excuses because we don't want to comply with the law. But of course, as legal service providers, we have a range of other obligations which make disclosure quite complicated. So it's really important that we understand that the same duty applies to us as everybody else, but the way in which that duty would unfold does have to take into account the practicalities and the ethical and legal issues that coalesce with our practice of law or practice of some other professional obligation or ethical framework, such as social workers. So what must be done is necessarily got a couple of additional considerations for us, and we're going to go into that in quite some detail. There are reasonable excuses already set out in the section itself, and they are quite straightforward. One is that it's already been disclosed to the police. One is that it's already been reported under a number of other mandatory reporting criteria, such as the Child Protection Act, the Education General Provisions Act, or the Youth Justice Act. So these are examples where a reasonable excuse means you don't need to disclose, where it's already been disclosed to the police, it's already been disclosed under one of these statutes, or possibly more complicated, where you get the information after the person's already an adult, and you have a reasonable belief that they don't want the information to be disclosed. And so this is allowing for the protection of people's human rights to privacy, and in fact other human rights, to give them the autonomy to make the decision that disclosure doesn't happen. But you have to form the belief that they don't want that to happen, that they don't want the information to be disclosed. So that in itself is a reasonable excuse. The last one is where both of these things apply, and this is where the adult reasonably believes, and the adult is you, reasonably believes that disclosing the information would endanger the safety of the adult, that's you, or another person, which could be the person giving the disclosure. Now, this doesn't apply to the offender, but you know that it does apply to the safety of the adult getting the information, or the person, or another person. In fact, that's not defined. But there's a second part to this one. You also have to be satisfied that a fail to disclose the information is a reasonable response. And so we've got these 4 examples of reasonable excuse. It's been disclosed either under to the police or under one of those statutory requirements. It's the victim's choice to not disclose, or that there's some danger or safety issues for you or another person to, if you do disclose, and that's a reasonable response. There are some real complexities around these provisions. They don't mention privilege, and they don't mention other ethical duties. These 4 categories do not address the situation where the person giving the information is a child themselves, other than the last one, where we talked about another person's safety might be endangered, where that could be a child victim. So I think if you have disclosures by children or those with an impairment of the mind aged 16 to 17, then you need to give very careful consideration to your duty, particularly the nature of informed consent, because there will be obviously some complexities around the giving of informed consent by children in that situation. So I don't know the answer to what happens where the person giving the information is a child. other than to say that should really force you to look very closely at these duties and think very carefully about the reasonable excuse provisions. That is, if the child does not want to disclose. They may want to disclose and then you don't have the same issues to consider, although the child may want to disclose and you may form a reasonable belief that this would endanger your safety or their safety. And so at times these duties, at times these reasonable excuses may create conflicts between the person giving the information and the person who gains the information and has the duty. Again, I don't want to make this more complex than it is, because it is obviously very technical, but you may have some conflicts with the way in which this section is implemented on a case-by-case basis. There are some other issues. The laws don't prescribe other kinds of abuse. For example, physical abuse, emotional abuse, neglect, and exposure to domestic violence are not anticipated by this. So we are dealing with a very strange situation where we have quite serious duties to report certain types of historic and prospective behaviour, or continuing and prospective behaviour, and not others. And so we do also need to be thinking about what are we disclosing? What is the nature of the allegations? And of course, many of these things go hand in hand with each other. The sorts of abuse that we've listed there that aren't included will often be alongside sexual offending or sexual violence or sexual abuse. But it is constrained to those sections we talked about earlier, chapter 22 and chapter 32, and not more broadly to these issues that I've listed there. Again, this raises yet another complexity around how we might comply with our obligation. There are protections for reporters, and if you in good faith disclose information, you are not liable civilly, criminally, or under an administrative process. Now, we don't know whether or not an administrative process or civil liability, how that interacts with our own disciplinary processes. For example, a complaint to the Legal Services Commission or a complaint to a professional board of some sort. One would think that this is giving you an immunity from those processes as well, but unfortunately in Parliament, its wisdom has not given us the detail that makes us sure that those protections are in place. My view is it would be included, but again, I can't give you that guarantee. Let's talk about the application of legal privilege, because I know that this is one of the key areas. The Act itself does not mention privilege, but the explanatory note does. And it says that the offences do not override any other privilege, including self-incrimination or legal professional privilege. They do, of course, override the religious confession privilege, because this in itself was a major hurdle to reporting of child sexual abuse by clergy and within religious institutions. So that one is overridden, but the ones that we care about most in terms of our own practice, in terms of self-incrimination and legal professional privilege, the explanatory note says it's not overridden. If only it were that simple, and I could probably end the presentation here, but unfortunately that is not the case. So what I've done is I've created now a presentation which talks about the application on two possible situations. You'll notice my very loyally asterisk there that says other situations may arise. And I say that because thinking through this presentation, I truly could not come to grips with just how many permutations there are in respect of this quite short and quite short provision. There's not a lot of detail there, but it certainly opens up a bunch of different scenarios. These are the two I think we'll encounter most commonly. So I've focused on those. Firstly, when the person giving the information is a client, or where the person giving the information is not a client. Remember and never lose sight of the fact that the person giving the information could be a victim, therefore a possible complainant. They could be the perpetrator, a possible defendant, or a third party and a possible witness. And so we are not always talking about a situation where the information that we get comes from a victim. In fact, it could come from a number of different places. But let's focus now on these two scenarios where it's a client and where it's not a client, because that really does split the difference for us in terms of how we respond. So let's talk firstly about a client. Now, a client-solicitor relationship is determined by a whole bunch of different principles and cases. I'm not going to go into those in detail, but there's some cases there if you care to look at them. But we have to be satisfied that our interactions with a person establish a client relationship to consider them a client. Again, I'm not going to go through these in detail. If the person that gives us the information is a client, then we have a series of questions. The first one is it privileged? And if it's not, I should say if it is, then no report is required. But that's not enough. We also need to ask ourselves, is it confidential? And we then may find ourselves thinking about the reasonable excuse provisions, but we also have to think about our conduct rules, which are a little inconsistent with this provision itself. Is there another reasonable excuse? And if there is, no reports required. Has it already been complied with? And those, has there already been notification made to the police? And if so, no reports required. If you get to the end of all of these things, it's not privileged, it's not confidential, there's no other reasonable excuse, and the section hasn't already been complied with, then you may well be in a situation where you have to comply with 229BC. Okay, but these are the questions that legal services should ask themselves before they go ahead and disclose. Okay, that's the checklist for you. Is it privileged? Is it confidential? Is there another reasonable excuse? And we track through those 4 before. Has it already been complied with? And then the question, can we comply with the section? Remembering that privilege, again, I'm not going to labour the detail of privilege, but privilege is about confidential communications passing between the client and for the purpose of their legal advice. Again, there are different sorts of privilege, legal advice privilege and litigation privilege. We presume that the explanatory note refers to all types of legal privilege. However, we also have limitations on privilege which do not extend to advice given to further or facilitate criminal or other unlawful purposes. And communications fall outside privilege can include things like immoral purposes or illegal purposes. So even this one instance that gives us a reasonable excuse based on legal privilege has in itself a number of technical issues we need to draw our minds to and think about, does privilege apply? And in fact, does privilege cover this situation? I think privilege is probably relatively well known. It's a constrained concept, but what is not a constrained concept for us, which is a broader concept, is confidentiality. Confidentiality is not mentioned in the explanatory note. There's some overlap between privilege and confidentiality. They have similar components, but they are different. Privilege is much more limited than our broader ethical duty of client confidentiality. And for other professionals tuned in today, privilege is also much more constrained than the broader ethical duties of confidentiality that you might find in other ethical frameworks. For example, the Australian Association of Social Workers Code of Ethics. There are many occasions where discussions can occur between a lawyer and a client where they're held in confidence, but they're not privileged. The essence of this ethical rule of confidentiality is that we must never disclose something which is confidential unless we are permitted to by the Australian Solicitors' Conduct Rules. They make very clear that confidentiality is paramount, except as permitted by Rule 9.2. And remember, this is premised on the person being a client. There's an engagement with the client, whether that be by way of a retainer or an implied contract, or however we find ourselves with a client. Mostly it'll come from simple interactions with the person where we agree to do some professional work for them as a lawyer, and we create a retainer, whether in writing or not. So we are not permitted to disclose confidential information other than as permitted in Rule 9.2. Here's where it gets a bit bumpy, folks. You can see that there are a number of exceptions to that rule. Firstly, where the client actually authorises disclosure. This is straightforward. If the client calls us and says, this thing happened to me, you form the reasonable belief that it's disclosable. You may have a conversation with the client about that. They say, I've never told anyone about this, but in fact, I'd like you to. Then they are expressly and impliedly authorising you to disclose to the police, and you, in fact, would be satisfying your duty straight away. 9.2.2, however, requires disclosure where compelled by law. It is not clear whether or not 229BC would be compelling us to disclose by law. I think it probably does, where privilege and confidentiality don't apply. But I guess more complicated is this. 9.2.3 is not so bad. We're not going to talk about that one in detail, but 2.4 and 2.5 are the ones that I wanted to touch on here, because they're the ones that look a bit like and feel a bit like the obligation in 229BC itself. And so we have we can disclose where we are avoiding the probable commission of a serious criminal offence, or where we're preventing imminent serious physical harm to the client or another person. And so we can see that there is some alignment between 229BC's objects and its wording and these existing disclosure exceptions. We know that 2.4 and 2.5, which is the avoidance of an offence or the avoidance of imminent harm, arise out of cases like Tarasov. And you should, if you haven't read that case, go away and read it. There's a lot to do on it. It's about the duty to warn, or really what has become a duty to protect. But there's also some Australian and other examples of how that law has been implemented. And I don't go into detail here. But really the cases that fit 9.2 require you to take ethical guidance before you make the decision to disclose based on that exception. So remember, confidentiality is king, and you would only take the view that you should disclose a confidential information under Rule 9.2 after you've taken guidance from the principal solicitor or PII rep or the Law Society or from someone else who can give you some guidance. Okay, so I'm sure you all get from time to time these cases where people make threats that they're going to commit an offence or threats that they're going to harm someone, and you take guidance. So in the sense of these disclosures, if someone discloses they are in, there's imminent physical harm, and then we do have that exception. This is probably explained better by looking at this way and saying, well, 9.2.1 allows us to engage in consent-based reporting. This is what we might call a forewarning approach, and this is what I suspect a lot of centres are already doing. 9.2.2 applies if there is no privilege, confidentiality or other reasonable excuse that is compelled by law. 9.2.4, that one about preventing an offence, is really similar to the old offence of misprision of felony, which is now abolished. And that's where you have an ability to disclose where there's a prospective offence to be committed. That's not going to help us for historic cases. It may help us for cases where there's some continuing abuse and prospective future abuse. 9.2.5 is probably the most important, and that is the one that says we can disclose if we think that a sexual offence is happening or is prospective based on the allegations made. Situation 2, where the person's not a client. Now, this is not straightforward for us either. A non-client can be that person that comes to us. They don't ever get to the point of seeing a lawyer. They may be referred on. They may get information from us, or where they may have some reason why they can't give us instructions, which could be we determine there's a conflict of interest, or they may have capacity issues. So the question of who is not a client, unfortunately, is not dealt with very well by our ethical rules or our ethical rulings. And in fact, one of the few examples of this, as I could find, was the American Bar Association's rule that talks about prospective clients, where we still have so pausing there for a moment, someone who's not a client may not have a privileged relationship with us, but they may still have confidentiality expectations. So if the person giving us the information is not a client, the question becomes, is it confidential? We're skipping that whole privilege question. The question is it confidential? And if it is confidential, then it may be a reasonable excuse to not report. But we've also got to consider those other duties that we had in 9.2. Is there a reasonable excuse? If not, then does another reasonable excuse apply, or has it been complied with? And we might need to seek guidance. So all we're doing for someone who's not a client is taking out the question of privilege, but we still have to ask ourselves, this person who's not our client is giving us information. Is it confidential? And if so, is there a reasonable excuse that would, is there another reasonable excuse that might apply? So this is the kind of checklist. And look, it's difficult to soak all this in today. You're going to have to go back and read through this checklist at another time so you can sort of think through these obligations a bit more closely. But that's your checklist for someone who's not a client. We have some duties to non-clients, and in fact, the Tarasoff case was all about duties to non-clients, where a psychologist at an American college was made aware of threats by a perpetrator of violence who failed to warn either the victim or the victim's family. The perpetrator then murdered his, I think it was might have been his former girlfriend, and the parents sued the college saying you had a duty to warn. And the court found that there was in fact a duty, and so this is that so-called duty to warn or protect. And so we're still going to have those sorts of broader duties that arise that are not dependent on the client relationship. So in the sense of client relationships, we're thinking very carefully about our obligations that are formed by our ethical obligations to clients, but for non-clients, we're thinking about broader duties. So there's some examples that are given by government itself. You're at a barbecue with family members. Your 14-year-old niece tells you that an 18-year-old at the party took her into a bedroom and got her to pose for a nude photograph. Government suggests this is a very clear example of reporting information to the police. Now, this is not at all adjusted to take into account the context that we're talking about today, but it just shows you the very broad application of the duty. This is not a duty that's imposed just on advisors or phone reception people or lawyers. This is a broad duty in the community. The second one is your adult partner confides in you they were sexually assaulted by a neighbour when they were 5. And they also say they don't want to make a complaint. And here's a really simple articulation of that third reasonable excuse. That is, an offence has been committed, but the victim themselves have made their own decision to not report, and you therefore have a reasonable excuse. How to report is very simple. You simply follow police procedures for reporting, and I think you would do that after you've already taken a bunch of advice from your manager or your ethical, whoever you talk to about your ethical obligations. I think this is one example where services may wish to actually get legal advice if they're unsure about reporting. And I've already given legal advice to a number of local agencies here in Townsville about whether or not they had an obligation to report. And in at least one of those examples, they did have an obligation to report. And so we had to run through the process of determining whether they had a reasonable excuse. They didn't, and they had to report. Now, I know a lot of centres are running what's called a forewarning approach. That is where you can make the person aware of your reporting duties so they can make an informed decision about whether to give you the information. Obviously, that needs to be understood by all staff who might be in receipt of information, whether from clients or non-clients. We could just call that service users. And it would be useful to have a script that can ensure that you have a consistent approach. Volunteers are a source of risk management. We need to be thinking about the contacts they have with people and whether they are resourced and aware of these obligations. And of course, as always, the question of impaired capacity will be something you need to turn your mind to in terms of both the information coming from a prospective or a historic victim or from a third party. Just as an example, the AASW Code of Ethics does give some detail about how social workers approach this forewarning approach, and that is they will inform service users that the information will be used for assessment and may actually be provided to third parties for legal or other reasons. And they bolster that by saying they'll only reveal confidential information where it's permitted by law or where it's to respond to a risk of harm or where disclosure is required. And so social workers' conversations with clients will already forewarn that the information that's given to them may in fact be provided onto a third party, such as is required by 229BC. You can apparently contact the department for information about this duty, but they won't give you legal advice, so I'm not sure how useful that might be. I haven't called that number yet or sent them an email, but it might be an option for you. Another area not considered in all of this is the application of the Human Rights Act. We are mostly functional public entities, so in considering our obligations under 229BC, we also need to consider the human rights of the people who are engaging with us. Again, thinking back to the fact that that could be a child, historic or prospective victim, it could be the perpetrator or a third party. And these people may have competing rights interests. So sorry to say, folks, it's yet another complexity that you might need to turn your mind to. But as we continue to apply the Act, we'll get better at making sure we do, in fact, take these considerations into account. So recapping, some of the R's, basically. It has retrospective application. It does reverse the onus on us. It requires careful consideration. It requires the consideration of reasonableness on a bunch of areas, forming a reasonable belief on reasonable grounds, a reasonable excuse, doing it as soon as reasonably practicable, and making sure you have a reasonable response. So there are so many. This provision is laden with consideration points for you about when you need to do something. There are clearly many rights engaged, including autonomy, to make sure that when we do get to the stage of disclosure, we have checked off the individual client or non-client's right to autonomy, including making a disclosure or not making a disclosure. There are many rules engaged, including ethical and conduct rules. So you do need to read it and you do need to reach out for guidance. I think that's all I had time for. I'm sorry that that is so much information in a short period of time. I think it will be a little clearer when you go back and browse it at your leisure, if in fact you ever want to do that. So thanks.
Thanks so much, Bill. That was a lot of ground to cover, but it is a complex and technical area, and I think everyone will be really grateful for your guidance through the steps of it. So thank you very much for that really thoughtful and informative presentation. We have had a few questions come through, so we'll just work our way through them. Apologies if some of these are a little of the same ilk. I'm going to try and work my way through that. The first question comes from Eugene. What if the disclosed offence is in a different state? So a jurisdictional question, really.
Sharing my screen just for a moment. Penny, I'm just making sure, is that...
Yes, we've come back to the holding screen, Bill.
Okay. How do I do that? Sorry.
So we've just, do you want to share your screen again? Oh, yep, I've got you. Yep, you're back. So just seeing it as it's not the full slide presentation, it's just the, yeah, if you just.
I'll just maximise it again, that's okay.
Yes, yeah.
Sorry.
That's right.
Sorry. Yeah, so Eugene had a question about
what if the offence has occurred in a different state?
I don't think it matters, to be honest. I don't think it matters at all. There's nothing in the provision that limits the application to the Queensland jurisdiction. That, from my perspective, in a CLC, that would probably be inquiry from somebody who wasn't a client, but you tend not to have clients out of state. But no, there's nothing that limits it to a client or a non-client who contacts us from outside the state at all.
Sure. Okay. Good. Thank you. This next question is also from Eugene, which is, how do we assess/reality test any third-party allegation for a reasonable belief?
I think the requirements that you have to form a view that a child sex offence occurred at a relevant point in time, and that the person was a child at the time, gives you at least 3 points of reference that require you to get more detail. So it does have to be some detail about the nature of what's happened before you take the step for disclosure. So if it was a third party giving the information, you may not get all the details you need, but you may. Again, there's no requirement that it come from the child victim themselves. It could come from their parent. It could come from a carer. It could come from a family friend. And so again, the obligations on you do not change depending on who the person giving the information to you is. But getting the details could be difficult if you're not talking to the historic child victim or the current child victim.
Okay, thanks, Bill. I think this probably answers the next question as well, which came from Jennifer about whether it applies to any adult, for example, adult members of a child's family or priests. Yes,
it most definitely applies to everyone. There are actually no people carved out from this provision. Priests have lost their ability to protect this sort of disclosure by the privilege of the confession or the sending of confidential conversations. So they now have an obligation to report, and I think the community at large now has this obligation to report. I mean, of course, it's not known within the community that they have this obligation. So I think prosecutions will be rare because we've got a situation where it's effective strict liability offence, serious penalty, and yet most people would not understand that they had a positive duty to disclose that information. So we've got a bit of a mismatch of purposes here, and the first prosecutions that we'll see, and I'm not aware there's been one yet, but the first ones we'll see what level of intentionality is required to found the offence.
Yes, I think that's a really good point, Bill, and I think there's going to be a real interest, isn't there, in the first prosecutions, unfortunately, because it's going to shed light on how this is going to apply in reality. Thank you. The next question comes from Marley. How would you gauge the ethics around reporting of suicidal ideation in clients based on Section 22?
Based on what, sorry?
On suicidal ideas or ideation?
Yeah.
So I guess that's to do with the level of harm.
I mean, I guess that would probably, I mean, if a client, well, if anyone contacted you and was discussing their own suicidal ideation, I think you would have, you'd have to be thinking about whether or not you had a duty of confidentiality if it wasn't a client. The approach that we take here is that we're very concerned about serious imminent physical harm.
Yeah.
We will contact the police. So, but every agency has to have its own risk management framework in order to deal with those sorts of interactions. We've recently done some more work here about understanding when we need to do that, because of course we have a fair number of clients who talk about those issues, and we have to be able to distinguish between those where we're concerned that they might self-harm and those where we think that there isn't proper intentionality or opportunity or a likelihood, I guess. It's a very difficult and very nuanced process, and we would mostly err on the side of caution, as I'm sure everybody else would. But unless, I mean, I guess if that suicidal ideation had a backstory of child sex victimisation or offending, then you may have a 229 BC situation where you might need to think about where, in fact, the suicidal ideation is a consequence of what might be a reportable situation. Certainly, in my experience, many victims of child sexual abuse have very difficult lives and can on occasion be very clear about a history of poor mental health and suicidal ideation. So I guess being open to the fact that the client's circumstance might be masking something like that historic child sex abuse experience. Sorry, that's not a very good answer, but that's sort of what was made.
Really good answer, Bill. Thank you. I think as you said, it's a really nuanced thing, and there's not really a straightforward answer through that. It's very much a matter of your instinct and your assessment of intentionality at the time. So the next question comes from Rachel. If we are satisfied that we have a duty to report, do we need to be careful about the information that we disclose in making the report? For example, police may ask demographical questions about the child. Is providing that information potentially breaching confidentiality?
Well, I think if you get to the point where you've decided you have to report about a client, then you've already taken the view that confidentiality should be breached because of Rule 9.2. So if you have a client and you are in a relationship of confidentiality with that client, as you always are, then I think unless you form the view that 9.2 is satisfied, you could simply rely on confidentiality as a reasonable excuse. So you wouldn't need to disclose. Look, thanks, Rachel. It's a great question. I'm presuming it's Rachel from there. There is a real divergence of issues here, because if someone calls you and says, my uncle is abusing me and has abused me in the past, that's a very different situation to my uncle has abused me in the past. My uncle has abused me in the past is one of those retrospective historic cases, but where 9.2 does not provide an exception to breaching confidentiality. Because remember, 9.2 is focused on the avoiding an offence happening or preventing serious physical harm from happening. So 9.2 does not have a retrospective consideration, but it does have a contemporaneous and prospective application. So you may have a very different thought process around the simple, the historic allegation as opposed to the one that's happening now, or I think it might happen. However, there's still a view that we may be compelled by law to disclose, and so you still may be able to disclose historic offences, because we might say, well, we're compelled by 229 BC, but then the privilege, the explanatory note says privilege is not disturbed. So the starting point is privilege is not disturbed. But if there's no privilege, or you feel you've got a need to breach because of imminent harm, then yeah, you would be disclosing. You wouldn't be worrying about confidentiality, because you've taken the view that in fact it applies, but there's an exception. There are a lot of intricacies in the way this provision applies, and it doesn't apply neatly with our ethical conduct rules, nor does it apply neatly with social work or other conduct rules as well. So there's a lot of open questions, but I think be aware of these inconsistencies and these misalignments, and when you get a case, that will give you an opportunity to focus in on, is there a relationship with privilege? Is there confidentiality? Is there another reasonable excuse? Okay. Because the operational idea of the law is to get you to disclose. So that is the approach expected.
Yeah, great. Thanks, Bill. I think that's really important to remember and really helpful advice. The next question comes from Ashley. Should you also be making a referral for legal advice re-injury claims for historical child sexual abuse?
Well, I think you certainly would. I guess I don't want to get too far outside what we were talking about today. And look, I really feel like probably it's been a little bit unclear in many ways. But I think if this is a client you're dealing with who discloses historic abuse, then you can put them in touch with an agency like No More, that has real expertise in dealing with these issues. And I'm sure no one deals with this issue frequently. So it will be interesting to see what they have to say. And I think Warren might be on this. I think Warren's still with Damo. But you certainly would be giving referrals to any place you thought were appropriate, because of course you're not telling anybody else about that referral. That's just advice to your client. So you'd definitely be trying to give them routes to support from counselling, health, psychological, any type of support that you could put around that client to kind of help them would be important. But focusing in on the actual requirement to disclose, you do have to, address those criteria first and foremost before you think about other things. Because of course this is premised on there being not only a protection or redress for a historic crime, but also to prevent ongoing and prospective abuse. And those cases where it's potentially ongoing or prospective, you're going to need to act much more quickly, because the obligation is live. You need to prevent what is potentially happening right now. That's the part that puts the pressure on to do it very well.
Great. Thanks, Bill. I'm just noting the time. We formally finish in a couple of minutes, but we still have quite a few questions to go. So, Bill, if it's okay with you, would we keep working our way through those questions?
And I don't mind at all. That's fine.
Okay, so people can stay on if they'd like to continue to be part of the conversation just for a few minutes. If you're not able to keep on, then please feel free to access the recording later. So the next question is from Ankur. With respect to the reasonable excuse that a report has already been made, is there a proactive duty to verify this?
So can you just repeat that? I just didn't catch the whole thing.
Sure. With respect to the reasonable excuse that a report has already been made, is there a proactive duty to verify this?
No, there's not, but that's certainly the sort of contemporaneous notes you'd want to keep. So you could prove that. Yeah, I think whatever steps you take in this process, whether it be the intake notes, whether it be details of the allegations and those other criteria you need to have about relevant point in time, you need to have clear notes. And so you would need to have good details about what the allegations were, what the information was, who it related to, when it happened, what it involved, but also how you formed your reasonable beliefs and how you applied any of the reasonable excuses and the information you relied upon to form those reasonable excuses. So absolutely. And in fact, the advice I gave to an agency in North Queensland was they had a phone, and we'd done this presentation or similar to them. A phone call came in, they contacted us. It was, I thought, pretty obviously one they had to disclose. The client had not disclosed it up until that point in time, and we went through the checklist, and they kept very detailed notes about all of those issues. It was kind of sidetracked by them asking the client about the allegations, who then said, well, I'd like to report that. So, but yes, we certainly went through a process of making sure that all of the details were documented. Really important to have contemporaneous file notes that show all those things I just did. So your kind of checklist of factors. But I didn't want to do a checklist because I think that makes people lazy. I think you need to look back at the law and think about what your obligations are rather than doing a tick.
Great, good advice, Bill. The next question comes from Maria. Working for a CLC as a social worker, are we covered by the same privilege and confidentiality as it is a legal service?
Exactly the same. I'll reframe that. I mean, this is the whole presentation itself, but people who work in legal centres, whoever they are, will have an obligation to comply with our risk management guide and to comply with the obligations of our insurance policy. it's a conversation you have to have with your director or managing person about how your obligations as a non-lawyer, as a social worker or a counsellor or a psychologist or any other professional, how they work with the overarching obligations of the centre. In most cases, those obligations that others hold are not incompatible, and they are not a problem to work into your kind of risk management strategy. But you do have to be aware, and all staff have to be aware of how they connect and how they work. So a good example is someone who has a mandatory reporting obligation that is different to this one. So they may feel they have a mandatory reporting obligation of a different nature. They should discuss that with the principal solicitor to make sure that how that obligation sits with the kind of practice itself. It's a tricky question because this used to come up a lot around child sex offending, and it's sort of been overtaken by this broader duty in 229 BC. I can't think of other obligations you might have that might be inconsistent, but I think this has actually brought most of those duties together under one broader obligation. So we probably don't need to have that conversation. We do need to have the conversation about the forewarning approach, because that is a part of the practice approach of social workers, for example. It hasn't really been a part of the practice approach of lawyers, but it does now need to be. So that's probably the easiest answer, is to say that this has really consolidated the need to have a forewarning approach within the broader practice of the CLC or a legal service. We've kind of ignored that before because it was a little too hard to align competing obligations. We have an overall management guide which does deal with a lot of those issues already. I should also say that's under review at the moment, and there will be a new risk management guide, I think, later this year.
Yes, great. Thanks, Phil, for that comprehensive answer. The next one comes from Amina. This question is a little long, so bear with me. It relates to the non-client scenario and the positive duty to get enough information to make a report. The question is, if we come into contact with someone, say at an outreach clinic or other one-off situation, who makes a disclosure that would impose a reporting obligation, but they don't give us enough information, for example, they don't give us a time frame when the abuse occurred, what is our obligation to chase people up to get more information so that we can make a report?
I mean, there's two ways of looking at this. The first way is to say, if you don't get enough information to form a reasonable belief, then you don't have an obligation to report. That's a pretty straightforward answer. So if someone makes a comment in passing that gives you part of the information you need, then I guess you could simply say, well, we don't have enough to form a reasonable belief. That's the first answer. The second answer is that because we don't know the extent of the intentionality required in a prosecution for one of these offences, we don't know if the law might take the view that we should delve further into that situation because we've got some and should be proactive to get all the information we need. I think I would probably take a middle course and say if I got a very, very partial disclosure that didn't give me anywhere near enough to form a reasonable belief, I would probably say to that person, look, it would be very, very worthwhile having a conversation with you about this issue in a confidential setting or at another time where we don't have to have a discussion with other people around and give them contact details. I think, taking reasonable steps to do that in a more confidential environment would be a decent thing to do. I don't think there's an obligation to sort of hunt down the detail if you don't have enough to form a reasonable belief. Because you could actually go a little sideways with this if every single time you had some part of the information, you could go on a bit of a hunt for it. But yeah, I think it's really looking at when people give you a disclosure about a historic or continuing offence. And I'm struggling to think of an occasion where you might just get some of the information. They might say to you, look, stuff happened to me when I was younger. I can't remember if I was a kid or an adult. That's probably a situation where you might need to say, look, I just need to say to you that there are some obligations to report historic child offending. It sounds like you may have been a victim. Can you tell me a bit more about what was happening at the time that might help you remember when it happened? You'd have that conversation about trying to identify when it happened. I should also say that it's unusual that you'd have a quick conversation with someone about this. So it's highly likely that the conversation you had with someone around these issues would be more detailed, would be longer, and you'd probably get to some more detail down the track. It's hard to abstract these examples, really.
Yeah. Sure, and I think there's, linking back to your previous answer around the importance of the forewarning practice coming through into what CLCs are doing would also be relevant in that space as well, wouldn't it? So we just got time for one more question, I think, which also comes from Eugene. I'm not sure if it's a question. He says, I assume that if there is any 229 BC disclosure, one would immediately notify the insurer. Do you think that would be the case?
Yes, I probably would. I probably would notify I'd notify the PII rep. I'd take advice from the PII rep. Look, can I say one thing that I think is the safest course would be that if you have what you think is a Section 229 BC disclosure, that you would seek advice from your principal and probably also from the Law Society and probably also from the PII rep. And so anyone who needed to know about it down the track was already looped in. It is a very serious step to take, but it is also one that has the objective of redressing or addressing child sex offending. So it's one that has very serious underlying objectives. So I think it's important to loop in all the relevant people at the time you are beginning to think about this. This is not an instance where you can try and sort this out on your pat alone. You would want to be taking advice from your senior colleagues and also understanding that it might impinge on your requirements to notify a potential PII claim. It may not be a claim, I haven't thought through that, but you'd definitely be talking to the PII representative about that for sure.
Great, thanks a lot, Bill. I think we might wrap it up there. There were a few more questions, but I think we've probably come to the end of the time, and we'll make sure that Bill gets those questions and can answer them for you later. So we are going to leave it there. Thank you so much for your time and expertise, Bill, and thank you all for your great questions and engagement today. It's been terrific. Just a quick reminder before you go that don't forget to complete the feedback survey that'll pop up on your screen once the webinar is closed, and that helps us obviously with our continuous improvement. Bill, it's been an amazing webinar. Thank you so much. There's lots of great comments in the chat thanking you for your terrific presentation and of how helpful it's been. So our thanks to you once again. That's it from us for today, everybody. Thank you so much for attending, and we'll hope to have you with us at our next webinar. Thanks very much, everyone.
Thank you. Bye.